Hello, I'm Jo and I'm the Regional Outreach Manager for the Midlands and the South. And today I'm going to talk to you about transferable harm. I'll be looking at harm, harmful behaviour and what we mean by transferable harm. I'll also explain how DBS receive referrals, what we mean by relevant conduct and who has the legal duty to make a referral. So who are DBS and what do we do? DBS are responsible for the delivery of the disclosure and barring functions on behalf of government. We operate the disclosure functions for England, Wales, Jersey, Guernsey and the Isle of Man, and the barring functions for England, Wales and Northern Ireland. DBS is governed by legislation and can only operate because the law allows us to. DBS certificates and all our other disclosure products are produced under Part 5 of the Police Act 1997, and DBS barred lists and all our other barring functions are allowed under the Safeguarding Vulnerable Groups Act of 2006 and the Safeguarding Vulnerable Groups Order pertaining to Northern Ireland of 2007. Now, we know legislation can be complex and we work hard at DBS to support you in both understanding and applying it. And we do have a number of resources available on our website which you might find useful. Things are slightly different in Scotland and Northern Ireland. So for residents of Scotland, both the disclosure and the barring functions are undertaken by Disclosure Scotland. And for residents of Northern Ireland, disclosure functions are undertaken by Access NI. But as you can see on the screen, the barring functions are undertaken by DBS. If a check is processed by Access NI or Disclosure Scotland, the Police National Computer, the PNC, covers the whole of the UK. So therefore, regardless of where you live and where you've obtained your certificate, the information will always be disclosed. So what is harmful behaviour? A person's behaviour can be deemed to be harmful in many ways, and harmful behaviour can occur in any setting. So the workplace, it could be a voluntary setting, it could be a setting outside of either of these, which is what we're focusing on today. What we're usually talking about is somebody either doing something they shouldn't or not doing what they should. And as a result, there's a negative impact on either themselves, for example, self-neglect, or in the majority of cases, it results in a negative impact on somebody else. So from a barring perspective, it's always about the negative impact on others that DBS would consider. When we're considering the impact on others, it's helpful to reconsider the question. So instead of what is harmful behaviour, thinking about how can someone's behaviour be harmful to others from a safeguarding perspective. So what do we mean by this? Well, it can mean many things because safeguarding is such a wide area across the UK. There may be many similar but slightly different definitions of what safeguarding means to you or within your organisation, and which in part is defined by the part that you may play. It may be preventative, dealing with the aftermath of abuse or dealing with perpetrators. Harm is the detrimental effect or impact of an action or inaction, so the abuse or neglect. It can be a psychological, emotional or physical injury. The impact of abuse on individuals can differ greatly from person to person, dependent on the circumstances of the abuse and their ability to cope with the aftermath or consequences. So it's important that anyone making a referral to DBS includes any information that they have about the impact of the alleged abuse on the victim. Now, we still refer to it as alleged abuse when a case comes to the DBS, even though an organisation may have found it proven. What we're doing, we're not asking anyone to interview victims or create a victim impact statement because in some circumstances, this may lead to additional distress being caused to the victim. But if the victim has provided an account of how the individual's behaviour has impacted on them, or an observation is made by a professional of that impact regarding things such as changes in behaviour since the abuse occurred, please include that information in the referral because that information helps us understand how harmful somebody's behaviour has been and also helps determine potential future harm. So there are three ways that DBS can receive a barring referral. Firstly, we've got discretionary referrals. So these are referrals that are submitted directly from organisations like yourselves to DBS because they've got concerns that an individual may have harmed a child or vulnerable adult or put them at risk of harm. So these referrals can come from employers, including voluntary organisations, sporting organisations, agencies, keepers of registers and supervisory authorities. But actually, in the interest of safeguarding, anyone can make a referral at any time. We've also got the auto bar referral. So this is where somebody is convicted of or cautioned for an automatic inclusion offence. So these are serious offences that are already set out in law, which would then require DBS to bar that individual from regulated activity in the relevant workforce. And finally, there's the disclosure information referrals. So this is when information has come to light because an individual has applied for an enhanced check with one or both of the barred lists because they're looking to work in regulated activity. And if the police national computer identifies particular information, this application will automatically go to barring for consideration as to whether that individual should be considered to be barred. So just as an example, the types of information that can trigger this type of referral is things like relevant police intelligence, convictions or cautions, or actually maybe information from the family court, such as having their own children removed. So those are the three referral routes where we receive referrals to DBS. So I mentioned in that previous slide that anybody can make a referral to DBS in the interest of safeguarding. But there are also occasions when there is a legal duty to make a referral to DBS. And the responsibility to make that referral lies with either the regulated activity provider. So these are employers, voluntary organisations, sporting organisations who are responsible for the management or control of regulated activity and make arrangements for people to work in regulated activity. And you've also got personnel suppliers. So these can be employment businesses, agencies, educational institutions who maybe supply students on placement to hospitals or schools. So there is a legal duty for these organisations to refer an individual to DBS when certain conditions have been met. The duty to refer applies even when a report has been made to another body, such as the local authority safeguarding team or the LADO. The duty to refer applies irrespective of whether another body has made a referral to the DBS in relation to the same person. A person who is under a duty to refer and fails to refer to us without reasonable justification is committing an offence, and if convicted, could be subject to a fine of up to £5,000. If you're a sporting organisation, your governing body may support you if you think that you have a case that needs referring to DBS. If they're the ones who view the DBS certificates and make a decision on somebody's suitability, then they would be the ones with the legal duty to make a referral. So, for example, in grassroots football, the FA would ask to view a DBS certificate if there was information disclosed to decide on whether that individual was suitable to work in regulated activity. So they would be the ones making arrangements for them to work in regulated activity and would therefore be responsible for making the referral to DBS. To satisfy the legal duty to make a referral, there are two conditions that need to be met. So the first condition covers the person being removed from regulated activity. So this could either be proactively through dismissal, but it could also be through other ways, including them resigning voluntarily. So if it could be through a sporting, they do a coaching role and they walk away from that role, for example. It's all specified in legislation. It could be redeployment. So you move them from one area of the business or the organisation to another where they're not in regulated activity. It could be they've retired or they've been made redundant. Because while they may no longer be able to cause harm in your organisation, they could still go on to get another job with another employer or volunteer in regulated activity. Often for those who resign, they do so before or during disciplinary proceedings, but it's still included in the legal duty to make a referral. The second condition is where that you think that individual has either engaged in relevant conduct, satisfied the harm test, or received a caution or a conviction for a relevant offence. And I'll talk through relevant conduct and harm next. So relevant conduct. So this is conduct that endangers a child or adult or is likely to endanger them. Is actions that if it was repeated against or in relation to a child or adult would endanger them or likely to endanger them. So this means that if something happens outside of regulated activity, so it could be, for example, an individual is involved in an altercation, a fight, violent conduct on a night out. But if they did those actions against people while working in regulated activity, would obviously endanger them. So that's what it means by if repeated against or in relation to. It's also, relevant conduct is also involving sexual material relating to children, including possession of such material, involves sexually explicit images depicting violence against humans, again, including possession of such images, or is of a sexual nature involving a child or adult. So relevant conduct is an action or inaction that has harmed or placed a child or vulnerable adult at risk of harm. It is a legal term which is defined for both children and vulnerable adults under Schedule 3 of the Safeguarding Vulnerable Groups Act 2006. So the harm test is satisfied when relevant conduct can't be established, but there are still some serious concerns which may satisfy the harm test. Not everything needs to be an action, so sometimes people may express thoughts or feelings which, if acted upon, would cause or put somebody at risk of harm. So what is harm? Unlike relevant conduct, harm isn't defined in legislation, so would be considered in its widest of context using a dictionary definition. Harm can be intentional, non-intentional, it can be direct or indirect, and can include some of the following. So, for example, harming a child or adult could be physically pushing a child to the floor during a training session, causing a child or adult to be harmed. So this could be not supervising a child during a trip, resulting in a child going missing. Putting a child or adult at risk of harm. So this could be forcing a child to carry on training when they're injured, attempting to harm a child or adult, maybe attempting to push a child in anger, however, a colleague or another work employee stopping you. Inciting another to harm a child or adult. So this could be, for example, a head coach encouraging an assistant coach to physically punish a vulnerable adult, for example, for, say, not scoring a goal. So those are all examples of what is included in the harm test. So some examples of where harmful behaviour may be transferred into the workplace. As you can see, there are quite a few listed on the screen. I'm just going to read through a couple for you. So firstly, if we look at domestic abuse. So for example, if an individual is a perpetrator of domestic violence against their partner, we would consider a number of factors in regards to whether it would transfer. So things like, does the individual have a short temper? If they do, would the challenges of regulated activity be likely to exacerbate this, leading to violence in those settings? Is the domestic violence a means to get respect or control? If this is how they believe it's acceptable to gain respect and control, then there may be a risk that they will use violence to achieve these things in a regulated activity setting. Abuse of somebody's own children, including neglect and poor parenting. Somebody who struggles to cope with the responsibilities of parenting and as a result neglects the care of their own children raises concerns about their ability to provide care for anybody who they may be responsible for. And then we've got theft. So if somebody is willing to steal from, con, or manipulate others for their own financial gain, then regulated activity is likely to present them with easy targets for this type of behaviour. and therefore they're likely to pose a significant risk of harm in these settings. Anybody who's shown the propensity to significantly harm another individual in any context raises concern that they may harm a child or vulnerable adult in regulated activity. So that harm is going to transfer into the workplace. If you're making a referral and you know that harm has considered outside of the workplace, you should consider telling us about it. When we've received a referral and have established relevant conduct, we can then consider the appropriateness of a bar, which is based on an assessment of risk. What is the individual at risk of doing? What is the likelihood of them doing it in regulated activity? And what is the potential for harm if they do? Could behaviour transfer to the other list? Transferability is based on an assessment of how likely the risk of harmful behaviour in one context, say maybe out of work, could transfer into another, so into work. Could the behaviour transfer to the other vulnerable group? So this could be from a situation outside of regulated activity into regulated activity, involving one vulnerable group to another, or when no vulnerable person is involved, to one involving a member of a vulnerable group. We have our own risk assessment process, which helps us assess the level of risk through identifying the presence of risk factors. The assessment looks at whether an individual gains pleasure or satisfaction from harmful behaviour, because if they do, then they're likely to seek further opportunities to engage in harmful behaviour again. It also assesses whether an individual believes harmful behaviour is acceptable, either because of the outcome it achieves, or the belief that some people deserve to be abused due to who they are or what they've done, or actually some people have the right to abuse. If an individual believes the harmful behaviour is acceptable, they're likely to continue to engage in the behaviour again and are unlikely to safeguard against others who do the same. The assessment also looks at an individual's ability to form and sustain effective relationships, as individuals who are unable to relate appropriately to others are more likely to harm them. We also assess an individual's ability to manage their own behaviour, as again, those who struggle to deal with life and situations in an appropriate manner are likely to struggle with the responsibility of looking after others. To be able to make these assessments effectively, we need to have sufficient information to be able to establish the specific context of what behaviour has occurred, including the circumstances that led to the behaviour, as well as the actions following it. The details of an individual's response when challenged about their behaviour can provide significant evidence to enable the assessment of risk factors. Some points to consider. Barring casework decisions are only as good as the information they're based upon. So it's important that anyone referring somebody to us provides as much information as possible. Missing information relevant to a case could actually undermine any decision made, either to bar an individual or actually to take no action. For example, a decision could be made not to include somebody on a barred list. However, if we had received all the relevant information, that decision could have been to bar that individual. So not receiving that information means that that individual could continue to work in regulated activity, posing a safeguarding risk. Only when the referral form or documents supplied indicate further information may be available are inquiries made to relevant parties. DBS can't investigate, so we rely solely on the information from the referrer. We only make requests for information we believe is relevant and necessary to help us make a decision when considering a case for barring. Finally, when an organisation knows that harm has occurred, they should consider whether a referral is appropriate, even if a vulnerable person was not involved. If making a referral and you know that harm has occurred outside of the workplace or outside of regulated activity, so domestic violence or coercion, for example, you should consider telling us about it. More information regarding barring referrals can be found in our barring referrals guidance. And if you're unsure, ask. Remember, if you don't make the referral, who will? So for all resources and guidance for safeguarding children and vulnerable adults in your sport, go to safeguardingsports.campaign.gov.uk. You can also get support from our outreach advisors, and all their details can also be found on the website. Here are some more contact details, including the inbox for the regional outreach team. Alternatively, as I previously said, you can find details for your regional outreach advisor on the Safeguarding Sports website. Thank you for your time today, and thank you for listening.